Hi, my name is Vladimir Hrle. I'm attorney of law from Belgrade, Serbia, and today I will speak about Serbia's new criminal procedure code. This presentation shall be divided in three parts. First part will represent or cover the reasons for adoption and will be some sort of introduction. The second part and the central part of this presentation will be main features of this new code. In the third part will be closing remarks, and my own personal conclusion. Now, although Serbia is not a member of the EU, the admission procedure is speeding up as all political barriers have been removed. Due to its geographical position, Serbia is a very important country for transnational crime prevention. And therefore, there was a striding need for a more efficient criminal procedure code. The old system was very ineffective. The trial lasted for years, and there were indefinite adjournments of the hearings. I will come to that later. And for example, the rights of defense were not at the acceptable level, and for example, legal aid system practically did not exist. In a nutshell, this new code is a shift from inquisitorial towards adversarial. This shift was assisted or initiated, if you like it, by the Department of Justice, Criminal Division of the Department of Justice, for the overseas prosecutorial assistance. OPDAT states that its mission is to assist prosecutors and judicial personnel in other countries to develop and sustain effective criminal justice institutions. In regards to the efficient use of resources in the judiciary, the reform in the criminal proceedings led to changes in the criminal procedure code. In 2006, the new criminal procedure code was adopted, which emphasized and introduced the adversarial investigation. However, this 2006 code never came into force and was never applied by courts in Serbia. Why is that a case? Nobody knows, but probably political reasons might be behind this. In 2011, this new code, which is the subject of this presentation, has been adopted by the Serbian Parliament, and its full application began in October 2013. So this is pretty fresh. Main features. Well, as I stated, this is a shift from inquisitorial towards adversarial proceeding. In this respect, the investigative phase is conducted solely by the prosecution. The powers of the court, or the investigative judge, how it was called previously and now pretrial judge, is only to monitor this pretrial phase. The court has no duty to examine evidence proprio motu, or by its own motion. The court examines evidence only upon the motion of the parties. The court may order a party to propose additional evidence or exceptionally order such evidence to be examined if it finds that the evidence that is being examined is contradictory or unclear. So, this is only in exceptional cases in which the court will examine the evidence by its own motion. Furthermore, this new code is supposed to strengthen the rights of defense by emphasizing the equality of harm principle derived from the European Convention of Human Rights. Disclosure. A defendant or his defense counsel are entitled to examine case file documents and view collected objects serving as evidence, whereby the prosecution is required to enable a defendant or his defense counsel to examine case file documents, which shall be used as evidence. Conversely, and this is related to the discovery, because discovery is also a new feature in this Serbia's procedure code. Conversely, a suspect who has been questioned and his defense counsel are required, after collecting evidence and materials for the benefit of the defense, to notify the public prosecutor and to enable him, before the conclusion of the investigation, about the evidence that has been collected by the defense and which may be used as evidence. So, as stated, the discovery phase is now part of the code, and this is a very new feature, because on one hand we have the prosecution that is required to present its case, but on the other hand the defense is also required to present its case in the early stages of the proceedings. The defense may collect evidence and materials. They can take witness testimony, deposition at private premises or areas, of course with consent of the holder of these premises. And they can also propose to the prosecution to undertake certain evidentiary action. If the prosecution does not accept this motion for undertaking of the additional or more basic evidentiary actions, the defense may submit its objection to the pretrial judge. So this is one of the roles, as stated, one of the roles of the pretrial judge on the investigative judge is to monitor the pretrial phase. And this is one of the tools by which the pretrial judge monitors the pretrial phase by deciding on undertaking certain evidentiary action. Furthermore, we now have 3 types of agreements which the defense and the prosecution may conclude. The first type is the plea agreement. I will not go into the details of the plea agreement, because it's due to time constraints and the fact that this also existed in the old code, in the novelties of the old code. Not in this form precisely, but it existed. The 2 other types are agreement on testifying of the defendant and the agreement on testifying of a convicted person, whereby the agreement on testifying the defendant existed in certain form in the previous code. The agreement on testifying of a convicted person is a totally new feature. The prosecution and the defense may conclude the agreement if the testimony of a convicted person is crucial for detecting, proving, or preventing a criminal offense and outweighs the consequences of the criminal offense for which the defendant was convicted. Of course, a person convicted as the organizer of an organized crime group may not be a convicted person who could conclude this kind of agreement with the prosecution. Okay, let's go further into the proceedings. The indictment phase. Unlike the old system, the new code prescribes that the court has to review the indictment by its own motion. Meaning, in practical terms, this means that the indictment shall be reviewed even if the defense does not submit its observation or objection to the indictment, which is totally different from the old system, by which only in cases in which the defense could lodge the objection to the indictment, and extraordinarily the panel of judges would review this indictment. Also, in the old system, the indictment could be reviewed by the president of the panel. Could, I say could, because now, as stated, the court has to review the indictment by its own motion. So this is pretty much clear and different from the old. Okay. Main phase of the hearing. Prior to the main hearing, a preparatory hearing shall be held. The purpose of this preparatory hearing is for the court to learn about the evidence and the subject matter of the case at hand. The parties should raise factual and legal questions, which shall be discussed later at the main hearing. This hearing is held in private sessions, also no public. And the main purpose of this hearing, the preparatory hearing, is for the parties to propose the examination of certain evidence. What this means? It means that if the party does not propose the examination of certain evidence at the preparatory hearing, such party shall be precluded to do so at the main hearing. And this, I will now return to the thing I said at the beginning. One of the biggest weaknesses of the old system was the ineffectiveness of the trials and the definite adjournments of the hearings. One of the reasons for this indefinite adjournments was that the parties were free to propose evidence at any stage of the hearing, of course, until the court declares the hearing closed. But until the mere end of the hearings, the parties were free to propose additional evidence. And this led to indefinite, and I really mean indefinite adjournments of the hearings. Now, the parties are precluded to propose evidence at the main hearing. They can only do so in exceptional cases. They can only do this in exceptional cases, and I will not go into the details of it, but the important thing is to stress that the parties are required to present their case at the preparatory hearing, and this is like the core of the preparatory hearing. The presentation of the case by the parties. At the main hearing, and this is also a pretty new topic and raised so many concerns in the legal public in Serbia, is the cross-examination. Now, party which did not party may cross-examine the hostile witness, and in exemptional cases, the other party has the right for the re-examination, but this is only as stated in exceptional cases and in cases in which the court allows this redirect. The cross-examination, in my view, the full application of the cross-examination is possible but only in cases in which the court records the transcript in real time. So, in cases in which the court or the judge, by way of storytelling, records the transcript, the transcript into the minutes, will probably not be that efficient in terms of cross-examination. So cross-examination would only be productive in cases or at hearings in which the court records the transcript in real time. Why is this? This is the case, of course, and the colleagues from the common law system know this probably even better than I do. Cross-examination, every word is crucial. And that is why the transcript has to be recorded in real time. Whether this will be changed or, well, I don't really expect that the cross-examination shall be changed. This would be of course totally contradictory to the adversarial nature of this code. But I expect probably in the future that the court will find a way to introduce a different recording of transcripts, because this is also an relic of the old system, the storytelling way, and in my view, and lots of colleagues share this view as well, the recording of the transcript represents one of the biggest weaknesses of the criminal proceedings. Okay, as stated at the beginning, one of the main features is the introduction of legal aid provisions. The legal aid provisions are now implemented into this new code and exist only for 3-year imprisonment or higher sentence offenses. Currently, the draft of the new legal aid legislation is in the pipeline, and this will probably set aside this three-year limit, but until we see it, we're not sure. For the time being, the legal aid provision exists, but only for 3 years imprisonment or higher sentences offenses, meaning that a defense counsel shall be appointed to a defendant who, due to its financial status, cannot afford to pay fees and costs of the defense. Well, I would go into the conclusion. I will not go into the legal remedies part, because there are certain changes, but I think to the wider audience, this may not be that interesting. So I will not go into the legal remedies provisions of this new code. I will shift directly to the conclusion of my presentation. The adoption of the new code with modern, more efficient procedures, many of them which are borrowed from adversarial procedure, should, and I said in principle, should secure the transparency, clarity of roles, and overall fairness of the process. The new code might become an effective tool for the prosecution, whereby on the other hand, it could also strengthen the rights of defense. However, due to the short application of this new code, this is yet to be seen. And probably in a 1-year period, we will be able to see the full application and the full reach of this new code, and to detect the weaknesses of the new application and new application in the criminal procedure. Okay, I would wrap it up now, and would like to thank my colleagues who invited me to do this presentation, and thank you for giving me the chance to do so. Thank you, and bye.